Judge.
All right, just give me 5 minutes and I'll give you my ruling. Just for the record, the court will note that discovery issues have been ongoing in this case since, at least according to the court's docket, since October 31st, 2024. And with regard to the defense's motion to dismiss, and each of the cause numbers, the court will grant the defense's motion to dismiss for
Adjudicated. So we wanted to, and those records are not readily available to me. So we're requesting information from his file.
What are your questions?
Well, actually, I'd like to see all of it, Judge, because I don't know what I'm missing until I see it, right? What if he gave a confession? What if he gave a statement? I know we're not getting into the facts, but he's the main actor in this deal, and he's planned to the ag robbers.
Well, state if you could see if whether or not there was a statement made by him. I don't know if it should be reported.
If it's a juvenile, well, Judge, just I know this. I mean, I think Mr. Martinez is correct if it was given later, because at the time of the investigation, he did not speak with kids. I know that's part of the facts, but he did speak with the police. So we know that there's no statement there. But I can look into one. Definitely getting the plea paperwork and the steps and everything. I don't know how to do it over there.
So we're going to bring it back on March 6th. There's something about juvenile documents transfer requested. Yes, where are we?
Well, it seems to me that we were assuming that because he was a co-defendant and because they were prosecuting him more rapidly because the juvenile system works differently, that they could just transfer their crime scene videos, all the things that they had, just transfer them over to us, and they give it to me, and it's all good. But that juvenile detective, can you please send us everything you've got on those particular robberies that are in this court?
And that's something I probably need to give a tray about exactly which ones. I mean,
Okay.
I'm doing most. I think both of us are doing the real call from memory today. But I mean, if you don't mind, Judge, if we could go off the docket and we could actually get together and discuss that until the next setting.
All right, I can bring you back on May 5th.
May 5th is good, Judge.
All right, so May 5th for discovery. All right, so do you have all the discovery?
We don't, Judge. That's the reason we've been getting rescheduled, because the juvenile had so many cases. They actually resolved his matters.
And who is the juvenile? Is that the co-defendant or?
The co-defendant, yes, sir.
Judge, so regarding the juvenile co-defendant, we reached out to the juvenile division of our office. They represented to us that because the juvenile also had a large amount of cases, that they worked out cases that were actually charged in the case at the time when they reached the plea deal. The cases that are involving this defendant were not actually formally charged, and they never received any evidence for them, and they were resolved with a plea deal. And so there's no additional evidence at the juvenile pending.
Well, Judge, that doesn't mean they don't exist. In fact, the state suggesting that the investigating officers just gave up working on the files and never submitted them. They'll tell us that, that's fine, but I still want that evidence. This juvenile was charged with over 10 aggravated robberies, maybe as many as 15 or 20, right? He's a serial aggravated robber. My client was only charged in one day. And we believe we may be able to raise an arrest defense and other things like that. So the big picture of what happened with that juvenile and what he was up to and what he did would be very enlightening for the jury. And it could be even exculpatory in terms of me being able to prepare my arrest defense.
All right, so who's the prosecutor who handled that case? And is that the person you're reaching out to, that prosecutor?
We reached out to the investigator and the prosecutor.
Then this is what I suggest we do. If that prosecutor is over in juvenile, still in juvenile, then of course they can't be here. They can appear by Zoom. The cases that were taken in consideration, are there any police reports or DVDs or any type of body cameras or discs related to just those specific cases?
Your Honor, based on the family code, any juvenile matters, any prosecutor records, because Mr. Martinez does not represent the juvenile himself, he needs to go to the juvenile court, and he needs to make his argument to the judge to have us release anything to him.
So what you're saying is according to the family code, he's not entitled to a police report?
He's not entitled to the prosecutor's file unless the judge that has jurisdiction over the juvenile court binds it that he has a legitimate interest in it. And this is an argument he has to make to Judge Shaw. And then at that point, we can release whatever we have.
All right, so your argument is he's not entitled to the police reports that were filed, and he's not entitled to any body camera that are associated with the case that was taken in consideration.
Correct. Because it is a juvenile case.
I don't think the onus is on me to go plead for it. I think,
Yes.
I guess the better question is the state going to oppose my request if I make it?
We don't have them. Oh, they're not going to oppose it. They're not going to say anything. He wants to know if you're going to oppose his request
It's
when he makes it.
That one's 21 pages.
it's not necessarily whether we're going to oppose it, but that the judge has to find legitimate reason.
No, I understand that, but are you going to stand before the judge and say, Your Honor, we don't think there's a legitimate reason for this? That's what he wants to know. Because I think we all know.
I'm sorry to interrupt you.
No. I think we all know if the state's attorney were to stand before a judge and say, we are opposed to this, the judge is going to take that into consideration. So he wants to know if he goes and he requests it, are you all going to say, we're opposed to his receiving the information? I mean, if you are, that's fine, but he wants to know it beforehand.
I understand that, and until I know what his legitimate reason, I understand what he's saying here, but what's written in the motion will determine what we say to the judge.
So they're going to oppose it.
So it sounds like that.
So this is what, I mean, you can go there, you can do that, or either, you know what you can do? You can subpoena all of those police officers, and if you want to have a hearing and subpoena all those officers and force them to bring in the police reports they made, the body cams that they have, then the court will make a ruling.
And I see the logic of your suggestion, Judge. The problem is, if I don't see the file, how do I know that I have all the officers?
Mm-hmm. Well, this is what we can do, and I've done it before. Do you know of any of the one officers who were involved in that case?
Oh, of course, I have my discovery from.
All right, so this is what we can do. We can set it for a hearing in this court because they've told you they're going to oppose it, right? So I think once they speak to their supervisors, whoever they speak to, they're going to oppose it. So just subpoena whatever specific officer you want to subpoena, bring them here in the court, and you can go over there and complete file with them and tell them you want body cams, you want this, whatever you want, and then I'll make a ruling on whether or not it's admissible. I'm trying to cut through all of the red tape because otherwise what's going to end up happening, you already know. You're going to go over to juvenile. You're going to go before Judge Shaw. The state is going to object to your receiving this information, and you're going to have to make whatever arguments you want to make over there. But just let me know what date you want to have that set for. Spend all day speaking to whatever witnesses you want to subpoena, and we can go through the police report line by line and make sure that you have the information you need in order to go forward on a jury trial if your client so chooses.
But the juvenile prosecutors, they're just like boots. So.
All right, so I thought we were supposed to have a hearing with them.
We did.
Well, I know they were by Zoom saying they're not going to give it, but I said subpoena it.
We did. And I don't think their position hasn't changed. They're basically telling the court, doesn't matter what you tell us, we're not giving you.
Oh, yeah, we'll see about that.
Yeah. But we're trying to get around that problem by seeing if we can resolve some of the cases, and we've been exchanging information and trying to get there.
All right, so I would suggest follow subpoena and subpoena the documents, and they'll have to file a motion to quash, and we'll have a hearing, and they'll have to rehear.
I can't make an informed decision without having those documents either. And I mean, I've tried to facilitate between this subsection of the office and that subsection of the office, and even in other cases, they just won't provide me with the discovery.
It seems like, and I'm fine with that, us having that meeting, but juvenile records is a matter of law, or just not open records. I can't subpoena things that.
No, I understand what you're saying. They'll have to file a motion to quash. I mean, people, you can file a subpoena on whatever you want to subpoena, and you can let them know that they're not allowed to appear by Zoom, so they'll have to be in court. We can get conversations started. Legally, they'll have to file a motion to quash, and they'll have to come in and have it heard.
But I will do it. This court's asked me to do it.
Because who knows, they'll show up and maybe they can tell you all things as opposed to giving you documents. So we're going to come back on August 20th.
Lynn, the chief of the felony prosecutors, he gave me a template of a motion to follow. Apparently, there's a procedure in the juvenile court to get the judge in the juvenile court to approve the release,
Yes.
which if the juvenile prosecutor told us that 2 months ago, would have already been done.
Because I knew there was a way to do it, so I
I
was just,
drafted the motion.
okay.
The only thing that I'm missing is the case number in the juvenile court, because apparently you can't even get that information, but I'll try. And so my goal is to get the coordinator in the juvenile court to set me on the docket on my motion. If they grant it, I get what I need, we're done. They deny it, we'll be back here to talk about all the ramifications of that. That's,
Okay. I don't think they're going to deny
I
it.
don't think so either, Judge. We just haven't done the process.
All right, Ms. Ferguson. Set this late September. All right, that will be final discovery, and I'm sure that that judge will approve for him to have those records. And they'll probably do it with a protective order attached to it. So what's happening with this case?
We went to the second hearing. Judge Shaw has finally agreed to let us physically inspect both the court's file and the state's file, and then come back with more specificity if I want something duplicated. We would request at least 2 weeks for me to physically be able to go down there and look at it. The state has no objection to letting me go and view those. And that's as far as we've gotten since the last setting, Your Honor. But we did make that progress.
All right, Ms. Ferguson, I need to set for a jury trial date and a plea deadline date, and y'all can get a setting in February. All right, your jury trial date and your plea deadline date is going to be February 17th.
You still have tremendous discovery issues. I still don't have anything that I've asked for in terms of juvenile records. Matter of fact, the state gave me a listing of like 10 or 12 police reports. I've made my own request to the city, and they send me a letter back. We're not going to give it to you. So I keep running into the same merry-go-round. So, not only the state refusing to give it to me, but the city's refusing to give it to me. And I've thought about this backwards and forwards, and I think it's just an extremely unique situation where a juvenile is a co-defendant, here he is, Judge, with an adult, and case is actually going to maybe go to trial, et cetera, et cetera.
So the person who was sent to TDC, was it because of juvenile issues or something completely different?
He had more than 10 aggravated robberies, 5 of which my client is codependent, and the others he's not. Right? But they won't give me access to anything.
There is a motion you can file to get those.
We've already had.
I'm gonna pull into my memory bank. No, there's something else, because I just remembered I had something similar to this when I was a defense attorney. So I'm just gonna pull it from my memory bank, and I'll let both sides know. And then whatever you all want to do, you can do. All right, Ms. Ferguson, on this case, did they do the bench warrant today?
They haven't done it yet because I just got that information like within the last 10 days.
All right, Norma, how long does it take when a bench warrant is signed?
Maybe 10 working days, just bring the defendant up.
All right, so let's recall this in 20 days, and I'll sign that.
And I'll try to follow up. I did file a motion for the bench warrant, so I need to go find the order so I can get you to sign it. And I can tell you, Judge, I also have a motion to dismiss on file the trial grounds. This case is from 2020.
It's March 9th.
All right.
It's going on 2 years.
All right, State,
Yes, sir.
on this case, this is going to be called for March 9th, see about the bench warrant, and then we can hear their issue where they're requesting a dismissal for want of a speedy trial. And that has nothing to do with this court. I'm assuming it has something to do when it was filed.
It's been indicted for more than a year, Judge, I'm sure.
Okay.
So we actually had a hearing in front of the juvenile judge, and he denied us as well. Cover every base we can cover to try to get these records.
You know what? So here's my question for the juvenile people. If you have information that somebody is not guilty of an offense. You're telling me I'm not going to turn over any records because...
Well, it gets more complicated than that, Judge.
All right. We'll be back on March 9th, and the court will hear motions on that day, and we'll see where we are on the bench warrant.
The Judge, the court will recall, and I'll also bring up one of the reasons for today's setting was to bring the defendant, who was a juvenile who's now in TDC, to court because we want him to testify in our case. We can't even accomplish that because nobody has his birth date. I don't have access to his birth date. And I'm assuming Norma was never able to
All right, and
obtain that information.
The court will note for the record that defense counsel did file applications for a bench warrant. All right, you may proceed.
And so, Judge, this case happened in June of 2024. The defendant in this case has demanded his right to a speedy trial when we filed our notice of appearance back on June the 11th of 2024. The cases got indicted on August the 8th of 24. So he's been under indictment well over a year and a half. In terms of the harm issue, Judge, I'm just going to go through what I've recited in my motion. A critical witness, Joshua Garcia, who was a juvenile at the time, a co-defendant, was charged in juvenile court. And
just one moment. State, do you agree that's co-defendant?
It is, Judge.
All right, you may proceed.
And that his cases were adjudicated in the juvenile court. And then so much time has passed, Judge, he actually has been released from juvenile, and since it was a certification, he was then sent to TDC, which we believe he's there. We haven't actually found him. And today we were set for purposes of seeing whether or not he responded or that he was presented to the court pursuant to our bench warrant. In this case, Judge, if you recall, the defense has been asking from the very beginning, because he's a co-defendant, and because he has his own set of discovery, our defense is that my client was participating in the particular case he was involved in under duress. And we wanted to be able to demonstrate in the trial of this case the character and the nature of this co-defendant, what he had done in the past, his use of weapons, his MO, if you will, to show that because my client was only involved in this particular date and he wasn't involved in the others, to support our suggestion that he was operating under duress. But we can't get any of that evidence. If the court will recall, a year ago, this court had a hearing where the court asked the juvenile prosecutors to appear and to answer to why they wouldn't give us this evidence. And they, in fact, appeared on Zoom. And this court had the opportunity to question them and find out.
And they said they would not be giving the evidence.
They refused.
Yes.
One of the few times I've seen a lawyer in this court actually tell the judge, no, Judge, we refuse to do what you're telling us to do. Okay, so we stepped back from that and we regrouped. We found a provision in the code that says that we can petition the juvenile judge to have a hearing and to determine whether or not circumstances exist where he would order the disclosure of the records. So we did that. He denied it. They argued against it. He denied it, except to the extent that he said we could review the file that pertained to our case. Well, that was kind of pointless. We already have the file that pertains to our case because we have discovery from my client, but we'll give it a go. Never got them. We provided case numbers to the state. The state said we don't have those files. And to further clarify the record, juvenile prosecutors told us that they, in essence, took into consideration the cases that my client is charged with and never really pursued them because he had so many others that he got prosecuted on. So they weren't even sure where those cases were in the system. So that was another area in which we were not able to get the records. So we said, well, let's get the defendant here. Let's get the co-defendant here. Maybe we can get through him what we need, but we can't get him here. And I will tell you, Judge, that Abe Garza, and I think we've talked about this before, and I think he's been here before, is the juvenile's attorney. And he has suggested to me, and as an officer of the court, I will tell you that his advice to this client was going to be not to say anything, which is understandable because those cases weren't prosecuted. They still could be, theoretically. And he could expose himself to all kinds of problems, not only with those cases, but with perjury and everything else. So even...
Did you catch that? A courtroom moment so rare the judge actually calls it out in real-time, prosecutors allegedly telling the court, no, we refuse. That instantly changes the energy in the room. The defense isn't just arguing about missing paperwork anymore. They're arguing that critical evidence may have been locked away for over a year. And if that evidence could support a duress defense, that's not a small technicality that could change the entire case. Question for you. If evidence might prove someone acted under pressure or fear, should juvenile secrecy laws still override a defendant's right to a fair trial?
If we were able to get him here, I don't believe we would have been very fruitful.
And the court will note for the record that in regards to discovery, the request by the defense for discovery has been well over a year. The juvenile prosecutors did zoom in and they informed the court that they would not comply with discovery. And so, State, here's my question. With regards to juvenile, if it is information that is exculpatory, basically what I'm being told is you don't get it because it's a juvenile. They won't even give him the date of birth of the witness in order to have the witnesses appear by bench warrant. So, and that ship has sailed with regards to bench warranting him here, because this has been over a year. So that's what my understanding is from juvenile prosecutors, and their understanding of the law is that even if it is exculpatory, his client is not entitled to it because the other person is a juvenile.
And Judge, that's as confusing to me as it is to everyone else here. If it's relevant, then it is to be given to the defense. I don't know. My knowledge of juvenile law is rudimentary at best. My argument would be that any discovery that would come from the co-defendant would also be, all this stems from the same incident. So all of the discovery, be it for the co-defendant or for the defendant standing here, would be exactly the same because it all stems from the same incident.
But I mean, do we really know that? Because he hasn't been given access to it, and defense is entitled to exculpatory evidence. And I will say that the prosecutors in this court, you all are not the prosecutors who denied this defense the discovery that they needed. However, you all are all working for the district attorney's office. So everybody's responsible for discovery.
The distinction in this case is that there's a legal reason why it's not being provided. I believe under the family code, it's protected because the co-defendant was a juvenile at the time. And so we've certainly exhausted our resources. I understand that the state is a state and we are working together. However, the divisions are walled off from each other, so we don't have access to that information. So I want the record to be clear about that. I am not in possession of those materials. And then albeit whatever the juvenile prosecutor did come in here and say, the petition to the juvenile court was still made, and that court determined that it should not be turned over.
And I know that the prosecutors in this court did all they could to get the information to defense. Is that correct?
This is where the hearing takes a dramatic turn. Listen to the judge carefully. You can hear genuine frustration building. The court is basically wrestling with a legal paradox. If evidence is potentially exculpatory, meaning it could help prove innocence or reduce blame, how can the defense be denied access to it simply because another person involved was a juvenile? That's the kind of issue appellate courts end up dissecting for years. And notice something else: the prosecution in this courtroom is distancing itself from the juvenile division, saying the offices are walled off. Translation: everyone's pointing at procedure, but nobody can actually produce the evidence.
The attorneys in this
court, of course, Judge,
yes.
And I don't dispute anything the counsel just suggested to the court, but that could have been avoided.
Mm-hmm.
When they went to prosecute that juvenile, all they had to do was call the prosecutor in the 187 and say, hey, we're getting ready to go forward to this guy. This is our deal. We're going to work out. Let's discuss what you're doing with your case. Maybe they would have made mine go forward first. I mean, there's so many ways it could have been avoided.
Well, I mean, I know there are different ways it could have been avoided, but I'm just going to deal with the facts that's being presented before me. It appears that prosecutors in other courts, whether it's juvenile or not, people think that the law means that if there's exculpatory information, if it's a juvenile, too bad, so sad for your client. And the defense can't even get to the point of his defense of perhaps duress because he's not being given access to the information. And this has been going on for over a year. And I understand what you all are saying about the bench warrant with that, but we're still at a point where this court thinks under the law, the defense is entitled to exculpatory information, whether the person is a juvenile or in the juvenile system or not, because then what are we really doing? He can't present his defense, and nobody knows. For the record, nobody knows if it's exculpatory or inculpatory because he's not being given it. And obviously, based upon what the defense is presenting to the court, that their defense is or will be, he's saying as an officer of the court that he believes the documentation would show that.
It would help us to prove that point, we think, Judge.
Yeah. So is there anything else from either side?
Judge, I just understand that. I understand what the court has explained. I just don't believe that dismissal is a proper remedy in this case. And so I don't know if the court would be able to reach out to Judge Shaw.
And there it is, dismissal granted. After more than a year of discovery battles, missing records, failed attempts to secure a witness, and arguments over juvenile confidentiality, the judge reaches the conclusion every prosecutor fears. The defense simply cannot proceed fairly without the evidence. What makes this ruling so powerful is that it wasn't about proving innocence or guilt. It was about whether the process itself had become fundamentally unfair. Cases don't usually collapse this late unless the court believes something went seriously wrong behind the scenes. Do you think the judge made the right call here? Or should the case have continued despite the missing evidence?
Because I mean, that was his ruling. So at this point, my hands are tied.
Is there anything else from either side?
I think our position is pretty clear, Judge.
All right, just give me 5 minutes and I'll give you my ruling. Just for the record, the court will note that discovery issues have been ongoing in this case since, at least according to the court's docket, since October 31st, 2024. And with regard to the defense's motion to dismiss, and each of the cause numbers, the court will grant the defense's motion to dismiss for want of speedy trial. It will be based upon the defense's inability to proceed with trial due to the lack of discovery. Is there anything else?
There you are.
All right.